Now, let's go to judicial matters. We understand the Supreme Court has fixed October 22 for the hearing of a suit filed by at least 16 state governments challenging the constitutionality of the laws establishing the Economic and Financial Crimes Commission, EFCC, and 2 others. A 7-member panel of justices led by Justice Uwani Abba-Aji fixed the date after the states were joined by co-complainants and leave granted for consolidation of the case in the suit originally filed by the Kogi State government through its Attorney General. The states that joined in the suit include Ondo, Edo, Oyo, Ogun, Nasarawa, Kebbi, Katsina, Sokoto, Jigawa, Enugu, Benue, Anambra, Plateau, Cross River, and Niger states. The 16 states said they are relying on the fact that the Constitution is the supreme law and any law that is inconsistent with it is a nullity. To discuss this, we're joined by legal practitioner Liborous Oshoma. Liborous, thank you very much for joining us.
Yeah, thank you for having me.
Do the governors have the legal standing to challenge the EFCC's Establishment Act? And are there maybe prior court decisions that support or refute their claims against the EFCC?
Yeah, thank you once again. Yes, to answer your question directly, the governors they are the representative of their own state, and we operate a federal system of government, and so they have a right, they have every legal right to challenge any law that is not in conformity with the provisions of the Constitution that is applicable to the state. And in this case, what they are challenging is the EFCC Act, the NFIU Act, and the ICPC Act. Basically, the bone of contention here is Section 12, subsection 3 of the 1999 Constitution as amended. And remember the EFCC Act by the Supreme Court in the case of the Federal Republic of Nigeria and the WOKG had heard that the EFCC Act, the NFIU Act, and the ICPC Act came into being as a result of the United Nations Convention. And so to that extent, the governors are of the view that for any treaty to be operated in Nigeria, to be applicable in Nigeria, subsection 3 of section 12 says that the various states of the Federation must also concurrently assent to that law. And so the states are more than 16 now. I think as at the last count, about 21 or 22 states that have joined. And so their contention is that not having been part of, the making of that law, not having assented to the EFCC Act by way of the provisions of Section 12, subsection 3, and then the law cannot be applicable to them. And I want to quickly take your mind to the Naira redesigning. If you remember, the Supreme Court ruled that the Naira redesigning cannot be applicable as at that time that was introduced, because the state governors also, argued that by virtue of the CBN Act, if the Naira redesigning must take effect, then the Council of State must approve it. And that there was no time the Council of State met and that the governors became part of that, approval for redesigning of the Naira. And so it was to that extent that the Supreme Court nullified the latter implementation of that law. And that's basically what is happening here also. The governors are saying, look, if you must implement the EFCC Act in their state, then they must be part of the making of the law by way of concurrent, approval, just like a constitutional amendment, basically.
All right. The ordinary man will be concerned as to why are the governors so invested in this case. Some of them would also allege that since it originated from Kogi State, this might have been a preemptive measure by the then state government to stop the EFCC from investigating it, considering, the all the controversy around the former Kogi State Governor Yahaya Bello?
Yeah, basically, this has nothing to do with Yahaya Bello or Kogi State in particular. This is not the first time that the governors are challenging the provisions of the EFCC Act. They have challenged it before, and then, I think it was on a different ground that the Supreme Court had ruled. That was on the applicability of corruption charges, on the ground that the country running a federal system of government, that the federal government cannot unilaterally look into the states, into the funds as approved by the State House of Assembly. That was the ground upon which this was challenged before, and the Supreme Court was of the view that the corruption being a national issue, and then the federal government had powers to look at it and tackle it, from the center. But the ground upon which they are challenging it now is completely different. It is a premise on Section 12 of the Constitution. And so, if you look at all of this, it boils down to constitutionality. It boils down to the fact that we should do the right thing, when it should be done. What this basically means is that the federal government should give the state, if we say we're running the federal system of government, the federal government should give the state opportunity to also approve of any law, any treaty that the federal government will enact into law, as provided for in Section 12 of the Constitution. So that's basically the lacuna there that the state government are basically, hinging the argument on. And if it's about Kogi State, then it will just be, if it's about Yahaya Bello, then it will just be a Kogi State and the federal government thing. But like I said, as at the last count, it's now about 22 states. Almost all of the states are joining. And so for them to be unanimous on an issue truly mean that the federal government need to look back, carry the state along in the process of lawmaking so that they can all be unanimous and, on the issue.
Beyond the state governors, what should interest Nigerians about this case that is now at the Supreme Court?
Yeah, beyond the state governors is that what should interest Nigerians? It is easy for us to say, oh, yes, we're all fighting corruption. But in fighting corruption, we should not fight corruption from, a standpoint. I want to see a situation where every law in Nigeria should be properly domesticated, and that even at the local government level, we should be able to have an institution that, would fight corruption at the local government level. Not a situation where you just have the federal government, you have the Nigerian police, you have the all controlled by the federal government, you have the NFIU, you have the ICPC, you have the EFCC, all controlled by the federal government. And that's why I consistently maintain that what we have is a big local government where the president is a local government chairman. And so where we pretend to run a federal system of government. So there's a need for all the federating unit, all the components, to be part of the process of lawmaking. That's actually the essence of Section 12. It's as good as the EFCC Act is, and as good as the EFCC is, because we cannot shy away from the gains that the EFCC have made so far. But I think that there's need for us to have a proper footing, for the EFCC as a commission. So as tomorrow, a pharaoh that does not know Joseph will not come and say, well, since there's no proper footing, then you can just, yank it off the way it was introduced in the first place. So the proper thing needs to be done. We cannot undermine the gains of EFCC, but at the same time, there's need for us to have it properly footed within the context of our laws.
We'll have to leave it there for now. Thank you very much, Liborous, for speaking with us.
Always my pleasure. Thank you.